Hi, my name is Travis Lindsay, and I am here for the CSUF Startup Incubator. CSUF, if you don't know, stands for Cal State Fullerton. We have 40 some odd thousand students, and a number of those students, a couple hundred, I think, are entrepreneurship students. And so our incubator helps them and community members launch their businesses. And one of the other things that we do is host talks like this one today with great speakers like Justin Sanders. So, Justin, please take it away.
Cool. Yeah, let me go ahead and share my screen real quick. Yeah, as Travis said, my name is Justin Sanders. I'm an intellectual property attorney. I work primarily with startups and small businesses, helping them identify what IP they have or intellectual property, and then helping them protect that IP through filing patent applications, trademark applications, things like that. But I'm also a resource to a lot of these local entrepreneur organizations, including Cal State Fullerton Startup Incubator, and it provide a lot of these resources at no charge. Trying to help provide a little bit of self-help guidance for those of you who are trying to do some of this on your own. And so kind of related to that, the talk today is going to be focusing on patent filing considerations. So if you are potentially interested in trying to prepare and file your own provisional patent application, then this talk will provide you with some guidance on how best to do that. In addition to providing just some kind of general foundational knowledge on the area of patents, because it can be a tricky minefield of a process, and certainly one where you don't want to go too far without having a patent attorney help you with that process. But again, some of the stuff you might be able to at least tackle on your own as a starting point, to keep costs down, particularly again if you are kind of on the typical startup shoestring budget. Um, I also note that these slides will be provided to you after the presentation, along with a couple forms that I'll reference later on in the presentation, in addition to kind of a template document that you can use if you are looking to try to prepare and file your own provisional application. So all that will be provided to you after the presentation. If you have any questions as we're going along here, feel free to type them in the chat as they come up, or if you prefer just to ask your question verbally, you can raise your hand, we can unmute you, and you can ask your questions. Since it's kind of a smaller group today, I'll take any and all questions, whether it's anything specific to what we're talking about here or any other IP related questions you might have. Though for those, let's go ahead and save those till the end, and I'll answer those as time permits. So jump right into it then. What we'll talk about today, eventually we will get into the provisional stuff, but I want to start with just some general kind of patent basics, just to give you kind of a general overview of what patents are, what they do, how they work, all that kind of stuff. And then we'll touch on patentability searching if you're looking to try to better determine whether your invention might be unique enough to be patentable. And then from there we'll get into provisional applications, how to prepare and file them. And then I'll touch on just some additional considerations at the end. Yeah, before we get into that though, just want to note that there are, as you may know, four different types of intellectual property. Again, we're going to be focused on the first one, patents, today. But the four main types are patents, trademarks, copyrights, and trade secrets. And so, in short, patents are what we use to protect inventions. So if you come up with a unique product or service or other type of invention, um, that's what we use to patents for, is to protect those types of intellectual property. Um, Trademarks are what we use to protect what we call the source identifiers. So in other words, like the name of your business or your product, a logo, tagline, things like that. Those are all what we call source identifiers, and those are all protected as trademarks. So when you place these source identifiers on products or services, when you take them to market, protecting those trademarks could be very important for your business. Copyrights are what we use to protect what we call creative expressions. So the typical examples would be things like any kind of creative work. So books, movies, songs, videos, sculptures, paintings, drawings, etc. any kind of creative expression, usually that's going to be the realm of copyright. And then trade secrets are what we use to protect any confidential information that you might have within your business. Proprietary algorithms, recipes like the Coca-Cola recipe, for example, customer lists, anything that you have confidential in your business that you want to keep confidential, would be protected as a trade secret. So basically, whatever you come up with is potentially protectable through one form of intellectual property or another. Again, what we're going to be focusing on today are patents. So a patent basically protects an invention for a limited period of time in exchange for describing how to make and use that invention in a patent application. So in other words, if you've ever looked at a patent application or a patent before, basically it reads like an instruction manual on how to make and use the invention. And so the whole theory behind the patent system is that it's encouraging the sharing of information. So in other words, when I come up with something, the next best technology, rather than just keeping it secret and keeping it to myself, this patent system encourages me to share that information through filing a patent application. And if it's sufficiently unique, which we'll get into, then the government in any particular country, the U.S. for example, will give me this patent, which is basically this limited period of exclusivity where I am basically the only one that can practice this invention for that period of time. So that's the trade-off. I come up with something new, I share it with the world basically, and in exchange, I'm given this period of exclusivity. But the thought process then is once that patent expires in roughly 20 years, that information becomes public domain so that anybody can use it and build upon it. And in theory, come up with the next best technology at that point in time. And so the whole point behind the patent system is to share information and to further innovation basically by sharing this information. Um, so that's what you're getting though is when you receive a patent, you're getting this right to exclude or right to prevent others from making, using, selling, offering for sale, or even importing infringing goods or services in whichever countries where you have those patent rights. And so again, it's if I have a U.S. patent, for example, I'm not just able to stop people from making, using, selling, offering for sale in this country, but also importing infringing goods into this country. So if I have a patent on this widget, and someone's making knockoffs in China, my U.S. patent can't stop the knockoffs from being made in China, but I can at least use that U.S. patent to stop those knockoffs from coming into this country. And if I want to stop the knockoffs in China, I can get a patent in China as well. And so that's part of the strategy in determining which countries might ultimately want to pursue these patent rights in. But that would be a conversation to have with a mentor or an attorney to help you figure out and strategize for which countries you might ultimately want to pursue these rights in. But ultimately, in any of these countries, that's what you're getting is these exclusive rights. And so, if you are particularly a startup or a small business, even if you're what we call pre-revenue before you actually take that product or service to market, if you're establishing these patent rights, you're getting these exclusive rights, or at least the potential, if you still just have a pending application. But that exclusivity or potential exclusivity is going to add value to your business because now you're doing something or you're establishing rights that allow your company to do something that competitors are not able to do. And that in turn is going to increase the value in your business. And if you're looking to attract potential investors or licensees or even purchasers, having these types of rights or pending rights is going to make you more attractive for those types of opportunities, especially when you're talking about investors. If you're trying to fundraise and you're trying to get meetings with potential investors, a lot of times the first question they'll ask is your technology patent pending? Meaning, have you started this patent process? And if you haven't, a lot of times you can't even get these meetings, so you can't even get your foot in the door. And so for a lot of different types of companies, this is a critical step to take. And as we'll get into, it's a time sensitive decision as well. So it's kind of the sooner you file, the better, which again we'll get into in a minute. But it's important to note that again, these rights are giving you the right to exclude or prevent others from practicing this invention without your permission. Um, but a patent is not a grant of permission to take your product or service to market. So what I mean by that is one, you don't have to have a patent in order to take something to market. Um, it's just if you want to have the ability to stop others from taking that product or service to market, that's where a patent becomes important. If you want to exclude other people from doing what you're doing, that's where you want to have a patent. But there's a lot of products and services out there that aren't patented for one reason or another, whether they just don't rise to the level of being unique enough to be patentable, or the owner just didn't want to pursue a patent for one reason or another. Maybe they couldn't afford to. Um, like a clothing company, for example, if there's nothing unique about the clothes themselves, there's not going to be patents on the clothing items. So you don't have to have a patent in order to take something to market. They're just nice to have if you can get a patent for that exclusivity. Um, the other thing to keep in mind is even if you do get a patent, that doesn't necessarily mean that you are able to take that product or service to market. That's what we call freedom to operate. In other words, the ability to freely commercialize something without being infringing someone else's patent or even trademark rights. So if you've ever heard that phrase freedom to operate, that's what we're referring to. Can you take this to market freely without being hit with an infringement lawsuit, basically? Um, and so even if you do get a patent, there's still that issue of do you have freedom to operate? And what I mean by that is a lot of times, and as we'll get into, when patents are being awarded, they're not always being awarded on something that's completely brand new, but oftentimes they're being awarded on like what we call an improvement, something, or in other words, like a better version of something that's already out there. And so if you come up with a better version of something or a new combination of pre-existing components, if those improvements or those combinations are unique enough, you could get a patent on those improvements or combinations. But the potential issue is that if let's say I come up with a new product that incorporates components A, B, and C, and I'm able to get a patent on that combination of components. But if let's say someone else already has a patent on component A, if I were to take my combination to market without that patent owner's permission, I could be infringing that patent on component A. And so that's just something to keep in mind because essentially the issues of whether something is unique enough to be patented and whether something might infringe some other pre-existing patent, those are always two separate considerations, two legal standards, two separate things that always have to be taken into consideration. So I just mentioned that because if you do get a patent, don't just assume that you have freedom to operate. That's always something that you also have to look into, separate from whether you could get a patent on your own invention. And as I mentioned, these rights are country specific. So if you want these rights in the U.S., you file a U.S. patent application. If you want rights in Canada, you file a Canadian patent application. Each country has their own patent office, and you go through a similar filing process in each country. Though there are ways to streamline this process in multiple countries, and that is something where you'd want to work with an attorney to help you with that. So as we'll get into with filing a provisional application as a starting point, that might be something you can do on your own. But anything beyond that, you really should use an attorney to really help prepare and file these documents and keep track of all the deadlines and everything else. So as far as what's patentable, the threshold issue is, or I should say, the threshold inquiry is, an invention has to comprise what we call patentable subject matter. It has to be kind of fall within the realm of being something that's potentially patentable. And as you can see here, I mean, pretty much anything under the sun is potentially patentable. Um, where you've got things like machines or articles of manufacture, so hard goods basically, or even processes, so a method of making something, a method of using something, software, that's considered a process as well, the underlying algorithms, if you're trying to patent software. Compositions of matter, so new pharmaceutical, new cleaning composition, things like that. Or again, any improvements on those things. So if you come up with the next best version of something that's already out there, if those improvements are good enough, then those improvements could be patented. So basically, anything under the sun, as long as you've invented it, is essentially patentable subject matter. Um, Now, what's not patentable would be things that you didn't invent, but rather discovered. So, for example, if you discover some new law of nature, or some natural phenomena, um, patents are reserved for inventions, not discoveries. So you can't get a patent on a discovery. Now, if you discover some new law of nature and you come up with some new invention that utilizes that law of nature, you can get a patent on the invention, but not the underlying law of nature itself. Um, the other category of what's not patentable is what we call abstract ideas, which commonly, at least currently, kind of applies more so in the context of software, sometimes on the biopharma side as well. But essentially, what it boils down to is if an invention or a concept is just too abstract, not sufficiently concrete in detail or in execution, then it might not be patentable subject matter. So basically, you have to pull an idea sufficiently out of your head and put it into a sufficiently concrete implementation in order to get a patent on that particular concept or invention. Now, if you are in the software industry or are developing something that is software based, and you're looking to try to get patents around that, it really is. Those are cases where you should have a conversation with a mentor that's familiar with software patents, or better yet, with a patent attorney, to determine whether your particular software is potentially patentable subject matter or not. It really is going to be case by case, and it's going to come down to the specific details of your software, not just what it does, but also how it's doing those things. But essentially, what the patent office is currently looking for, just based on current rules, is they're looking for software that essentially is a specific technical advance over the prior art, in order to be something that's patentable. So in other words, they're looking for software that improves the computer in some way, allows the computer to do something it wasn't previously able to do, or allows the computer to do something better than it was previously able to do. And it's those kind of like technical improvements that are currently capable of being patented under the current rules. And just like any other area of law, these rules are constantly changing. And so this current rule has been around for about 10 or 11 years now. But I'm sure at some point the pendulum will start to swing back in the other direction. But again, the short answer is that if you are developing software, you definitely want to have a conversation with a patent attorney, or a mentor, to get a better idea of what your chances might be with respect to getting a patent on that particular type of invention, because it is going to be, again, case by case. So beyond that threshold inquiry, assuming that an invention falls within the realm of being potentially patentable subject matter, the main thing that the patent office or an examiner at the patent office is going to look for, is whether your invention is sufficiently unique. And when they make that determination, they're basically comparing your invention against everything that's in what we call the prior art. Now, that phrase prior art basically means any third-party disclosure anywhere in the world that predates your earliest application filing date. So, in other words, if I file my patent application today on my invention, let's say this is my invention here, anything that was out there before today, that might talk about something similar to my invention. That is all what we call the prior art. So it could be things like previously filed patent applications, or issued patents. It could be things like academic publications or just products that are out there on the market, or a YouTube video or a TikTok video, or any other kind of public display that's been recorded, such as like a web page or something else that could be later accessed. Any and all of that is what we call prior art, as long as it was out there before your application filing date. So again, if I filed my patent application today, anything before that was out there before my application filing date is prior art. Anything after my application filing date is not prior art. So if I file my application today and a competitor comes out with something identical tomorrow, that does not count as prior art because it came out after my filing date. So I'm basically first in line, essentially. And if I'm ultimately awarded that patent, I could go back and sue that competitor if they are still selling something that reads on my patent. And so it's important to establish that filing date as soon as possible so that we're cutting off that universe of prior art. So once you file your application, you're essentially putting your flag in the ground as far as getting that filing date established and cutting off that universe of prior art. And that application filing date could be based on either a full, what we call non-provisional application, or just a provisional application that you prepare and file yourself. Now, kind of related to the whole prior art thing is what we call this issue of public disclosure. And this is probably one of the most important slides that I've got in my presentation. So definitely pay attention to this one.
Justin, I think we
Yeah.
had a question
Oh, yeah.
about AI and getting it patented. Rudy, do you want to unmute yourself and ask?
Hey Justin,
Hey, Rudy.
good to good to see you.
Yeah,
So,
likewise.
thank you. In particular, how is I know AI is a new market for patents, and what you were saying, I guess so. Basically, especially for AI, it just depends on what you're doing with AI, and it'd have to be a conversation independently.
Yeah, and it when we're talking about AI, I mean there that brings up a couple different issues. I mean, one, people sometimes ask me, well, I've got AI that develops something for me. Basically, the AI was the inventor of the invention, and then the question is, well, can I get a patent on that? And this rule is currently in flux, but I mean, currently the way that the rules read is that inventions, just like with copyright, copyrightable works, this is all reserved for human-based creations. And so if you have an AI that's developing things for you, trying to get a patent on those developments, it could be tricky unless you are kind of driving the development, and the AI is just more so a tool rather than really the sole inventor of something. And so that's one issue that comes up with AI. The other issue is like if I'm developing something that's driven by AI, I'm the developer. I've created this AI-based app or platform. Is that patentable? It's really going to come down to, okay, well, what is that platform doing? What's the functionality? And not just what is the functionality, but how is that functionality actually being implemented? So in other words, when you get patents on software, you're not patenting what the software does, but rather how it's doing it. And
Mm.
so it's the how being the underlying algorithms. And so if those underlying algorithms are sufficiently technical in detail, and those technical details are different from anything that's been done before in let's say other software applications, like if you're just adopting known techniques and applying it to a new use case, that's probably not going to be patentable. But if you've come up with a new technique that's never been done before, then that's where there's potential for patentability. So kind of related to that though is if your app is just being driven by some off-the-shelf AI,
Mm.
where you didn't really develop it, you're just kind of taking an input, dropping it into this AI black box that you didn't develop, and then receiving the output. That's probably not something that you're going to be able to get a patent on because all the how details were done by somebody else that created that AI. And so if, on the other hand, you've come up with your own new AI that you've developed yourself, there's potential for patentability there. The other potential angle that we look at sometimes is if you are using an off-the-shelf AI, if you've come up with a unique method of training it to do what you need it to do, then there's potential for patentability in those training methods. And so that's typically what we look at is either protecting the AI itself if it's something that you developed, or protecting the method of training that AI if you're using something off the shelf, or maybe it's a combination of both. But again, yeah, that's
Got it.
because of that, it's always going to be case by case. So the short answer, just like the typical attorney answer, is it depends.
Yeah,
But yeah, that's definitely why you want to have a conversation though, so we can get into the specifics of what it is you're working on, and then figure out how best to protect it.
great. Thank
Yeah,
you.
it depends is usually the answer for any sufficiently professional kind of question, isn't it?
Yeah,
Yeah,
pretty much. Yeah.
yeah.
Hey, Justin, we got another question
Yeah.
from Yame. How does prior art work if I file a provisional patent, then someone else files a non-provisional patent? I heard that the provisional is not really examined, it's a flag in the sand. Would my provisional
Yeah.
patent prevent the non-provisional from being approved?
Um, yeah. So the short answer is that when you look at and so basically the current rule is when you're looking at like two people that have essentially invented the same thing and have both filed patent applications on the same thing, it comes down to who filed their application first. So we're on what's called a first to file system. It doesn't matter who invents something first. It only matters who files their application first. And once you file that application, again, that's your flag in the sand, as you say, where you're establishing your filing date. And that filing date is established regardless of whether the application is a provisional or a non-provisional. So if you filed a provisional first, and then someone later files a non-provisional application, even before you get a chance to file your own non-provisional, if you filed first, then you're going to have the earlier filing date, and then you're going to be first in line compared to this other applicant. So, assuming that you ultimately follow through and you file the full non-provisional application, which I'll get into that in a few minutes. Um, Within the time window, then you would still be considered first in line, as compared to that other person that filed their non-provisional already. So yeah, so if you file first and then someone files after you, technically your application would be considered prior art compared to that later filed non-provisional application that someone else might file. So it's all about filing date and disclosure date, basically. So if I file an application, anything that was out there or that was filed before my application filing date counts as prior art. Anything that comes along after does not count as prior art for my particular application. That's good questions. So going back to this public disclosure slide, then what I mean by public disclosure, what the rules define it as, is any disclosure or display of your invention or commercialization of your invention that's not covered by an NDA. NDA being short for non-disclosure agreement, or sometimes they're referred to as confidentiality agreements. So in other words, if I start selling my product, if I offer it for sale, if I just use it out in public or post a video about it, etc. That is what we consider public disclosure. Now, where that becomes important is that disclosure relative to my application filing date. So what I mean by that is if you publicly disclose your invention before you file your patent application. So again, I haven't yet filed. I start to talk about my invention online, or I start to sell it, and I haven't yet filed a patent application on it. I can still file within 1 year from that date of first public disclosure, and I'll still be okay in the U.S. So in other words, if I disclose this invention today, let's say December 3rd, 2025, I would have until December 3rd, 2026 to file my patent application, either provisional or non-provisional. If I wait longer than a year, though, I'm out of luck. So if I disclose this today, and I wait until December 4th, 2026, so a year and a day beyond when I first publicly disclosed, my own earlier public disclosure now counts as part of that universe of prior art. So in other words, if I disclose and wait more than a year, I can no longer get a patent on that invention in the US. Now, that's just the rule in the US, that this 1 year grace period. Outside the US, there is no 1 year grace period. Canada and Mexico kind of have grace periods, but they've recently become a lot stricter. And so really there is no viable grace period outside the US. So what that means though is if I want to get patents in other countries, I need to have an application filing date that predates any public disclosure. So if I disclose this invention today and I file my US application tomorrow, I can still get a patent in the US, but I can no longer get patents in other countries because my own prior public disclosure predates my earliest application filing date. And now I'm out of luck for other countries. And so if you want to keep at least open the option of getting patents in other countries, then the rule of thumb is to get your US application filed before any public disclosure takes place. So if I file my application today and then I disclose my invention tomorrow, well, I've already got an application filing date that predates that public disclosure. So none of this is an issue then. It's only an issue if you publicly disclose before you file your patent application. And as I'll get into in a second, if I filed in the US today, I've got a period of time to then follow up and file in other countries. And if I do it on the appropriate timeline, all those applications will be given my US filing date as their filing date. So in other words, they're all treated as if they were filed on the same day. And if that date predates any public disclosure, I'm going to be okay to get patents in those other countries. So it's something to keep in mind as you're developing things to keep them confidential until you get that patent application filed, or at least until you make the decision whether or not you're going to pursue a patent. If you decide it's not worth pursuing, then fine, go ahead and publicly disclose. But if it is something that you might potentially pursue a patent on, keep it confidential until you get that at least the US application filed. At that point, the invention is considered patent pending. You've got your filing date established, your flag in the ground, and then you can go ahead and publicly disclose after that. If you have to disclose to people in the meantime, let's say that you're working on software, but you need to hire a software developer to help you actually develop it, or you've designed a mechanical device, but you need to talk to manufacturers to figure out how best to actually make this device. In those situations, you might have to disclose details to people to get it to the point of being ready to file a patent application. And in those situations, just have those people or those entities sign a non-disclosure agreement before you tell them anything. Because if you do that, now those are considered confidential disclosures, not public disclosures. And so you avoid all these issues by doing that. So keep inventions confidential unless and until you get that patent pending status once you file that patent application. And so just use those confidentiality agreements in situations where you have to disclose to people in the meantime.
Justin,
Yeah.
Yami's got another good question. But what if I publicly disclose today and someone else then files a patent application on it? Am I still protected?
And yeah, another good question. So you are not protected, but you've also by virtue of your public disclosure, you've created prior art against that third party. So if you publicly disclose today, and someone, let's say, files a patent application tomorrow, your public disclosure would prevent them from ultimately getting a patent. But at the same time, if they've created prior art by filing this patent application, they've also now prevented you from getting a patent as well. And so this kind of issue of prior art, the universe of prior art, is all going to be relative to each kind of individual inventor or patent application. And so in that situation, you disclose, then someone else subsequently files or publicly discloses themselves, you've essentially kind of canceled each other out as far as the ability to get a patent on that invention. Your activities count as prior art against them. Their activities count as prior art against you. And so it's still something where you want to file sooner rather than later, so as to establish that filing date, not just to or better protect against your own potential public disclosures, but you don't know when somebody else might be publicly disclosing or filing an application on something similar. And so I never like to be a fear monger in any of this because that's the unknown is like, okay, how many people are working toward a similar solution to the same problem? But really the rule of thumb is file early, file often when it comes to patent applications. Anytime you come up with something, as soon as you have enough details in place as far as how to make and use that invention, it's good practice to get that application filed sooner rather than later so that you can get that spot in line, so to speak.
And Justin, Corinne has a question. Corinne, can you unmute
Yeah.
yourself and ask it?
Hi, Justin.
Hey,
Thank you
good
so
to see
much
you.
for good to see you too. It's been a while.
Yeah.
So I was going to join a new venture with another founder, and the non-disclosure agreement actually had some clauses about the IP. So if I'm gonna be like sort of like the CTO for that venture, um, does the IP should be covered in that non-disclosure agreement early on?
Well, yeah, I mean, usually these non-disclosure agreements will just kind of provide, usually it's like a preliminary layer of protection where like parties are potentially going to enter into an agreement, but they haven't yet. They're still kind of negotiating terms and seeing if there's a potential relationship to be had there. And so yeah, usually those NDAs will include things like IP, but ultimately if you end up working with them, there would likely be, and there should be, a further agreement in place that kind of governs the entire relationship, what you're expected to do for them, what they're expected to do for you as far as payment and things like that. But then there'll be additional terms as far as like IP ownership, who's going to own anything that's created as part of this venture. There'll be like an additional confidentiality clause that just kind of reiterates the fact that you need to keep things confidential. And so, yeah, it's common to have that type of language in there.
Okay. And if I'm joining as a fractional CTO, not as like as an employee CTO, what would be the difference and how would the application or the modification and the improvements that I actually do to that venture be assigned to me, or is that actually something that could happen?
It really just depends. I mean, just like any other contract, I mean, anything can be agreed upon in writing as long as it's not illegal. And so the ownership of IP just comes down to what both parties are comfortable with. I mean, if they're hiring you to develop things for them, usually the expectation is that they are going to own that intellectual property, even though you're creating it for them. Whether you're an independent contractor or an employee, they're still paying you to create these things for them, and they would typically expect to own those creations. Now, if you feel differently, that would be something to negotiate now before you actually agree or sign that contract, where if you want to maintain ownership of this IP, that needs to be in writing in that agreement that's signed. Um, but I mean, on the other hand, if this is something that you're kind of separately working on, and then you've also got this other business going on the side. I mean, keeping that the intellectual property separate there, develop whatever you're developing on this side kind of is owned by this entity. Whatever you're developing for this company is going to be owned by this company. I mean, if there's any kind of crossover, that could definitely complicate things if they're like in the same industry, if you're working on kind of similar solutions to the same problem. Um, but yeah, I mean, it's all about what's kind of carved out in those contracts as far as who's going to own what, and that's going to be what controls. I mean, that's what a contract is kind of it's the rule book for that relationship, and whatever that rule book says is what goes, assuming that both parties signed it.
Yeah, yeah, because I was just about to sign this NDA, and I, like any tech person would do, I just took the all the contract and put it into ChatGPT and tell
Oh, don't do that.
what are the things, what are the red flags in these
You might as well just give it to a law student to look at. Um, but no, yeah, and again, I mean, usually what those NDAs will say though is like anything that the company currently has that's confidential, you agree to maintain that confidentiality. Usually it doesn't talk about like when something's created, who's going to own it. That's usually for a later agreement. So usually there's also exceptions in those NDAs where like if it's already information that you are already privy to, like you already knew about it, it's already out there publicly, you already developed something similar, like none of that's going to be covered by this confidentiality agreement. It's just basically any confidential information that they might disclose to you that you didn't already know about through some other source. You agree to keep that stuff confidential. But I'd be happy to take a look at it though, offline though, if you have more questions about that.
Yeah, that would be great. Thank you so
Okay.
much,
Yeah, no,
Dustin.
of course. Yeah, yeah. So just yeah, circle back with me on that.
Hmm. I
Yeah,
will do.
that's a good line of questioning because I mean, I'm guessing that most of the people who are listening to this, who are here, they're business people first. They're not lawyers. So when should, people like us, not like you because you are a lawyer, when should people like us come to a lawyer, asking questions, and how much does all that cost in general?
Yeah, I mean, definitely, you always want to talk to an attorney before you sign anything. That's for sure. And really before you enter into a relationship, there should be a contract in place. I mean, oral agreements, handshake agreements, loosey-goosey like email exchanges that are establishing some agreement. I mean, none of that is really ideal. Like you want to have an actual written contract in place, and whether it's something where you need to prepare it or the other side has prepared something for you to sign. I mean, that's where you want to bring in an attorney. Like, because if someone's giving you a document to sign, you need to make sure that it actually says what it needs to say, and that it doesn't say anything more than it should say, or state terms different than what you understood them to be, because whatever is in that document is what controls the relationship. So if someone said, "Oh, I'll pay you $10,000 to do this," but the contract says you're only getting 5,000. If you sign that contract, that's what you're getting. It doesn't matter what was said outside of that agreement. And so, talking to an attorney to make sure that the right written agreement's in place is important. Also, before you actually start a business, as far as like taking a product or service to market, you should be talking to an attorney to make sure that you're forming a business entity, whether it's an LLC or a corporation, because you want to protect your personal assets. You don't want to go to market as a sole proprietorship, because if something happens, you're getting sued personally and it's your personal assets that are on the line. So you want to have an LLC or a corporation in place before you start opening yourself up to potential liability. So that would be another time to talk to an attorney. Or again, if you're developing things that might be patentable, or protectable through whether it's trademarks, copyrights, patents, etc., having conversations with an attorney, preferably before you go to market. And so all this is typically like before you go to market, you want to talk to an attorney to make sure everything is structured properly, everything is that's potentially protectable is being pursued if it's something you're interested in. And before you enter into business relationships, again, talking to an attorney at that point. I would say those are kind of the big kind of flagpole points in the process where you want to uh, talk to somebody, and maybe not necessarily an attorney, but at least like a mentor. So like through the startup incubator at Cal State Fullerton. If you're part of that, you have access to a bunch of different mentors having different backgrounds and expertise in different industries. And so there might be like business attorneys that could you could speak to, or just mentors that have started a business before that can provide you with that guidance. So just talking to someone that has that experience before you get further down the road yeah, just a good thing to do.
Cool. Thank you.
Yeah. All right. So again, public disclosure, bottom line is keep things confidential until you get that patent application on file. So as to keep open all of your options. Again, the name of the game is obviously you're trying to protect your developments and prevent competitors from doing the same thing, but you're also building the value in your business. And so keeping open the option of filing patents in other countries is going to make your business more potentially more valuable, more attractive for some of these opportunities, because maybe you don't have the budget to pursue patents in multiple countries, but what if someone acquires you and they can afford to take those steps? Or what if you get an investor on board and they can help you fund those things? And so just at least keeping the options open is going to make you more attractive than limiting your options to only a US patent, which, I mean, that's still good, but it's relatively not as good as keeping open the option of getting patents in other countries. And so just file an application in the US before any public disclosure takes place, and now you're keeping open that option. We're kind of getting short on time, so I'm just going to skim through some of this and get to some of the more important slides here later on. But two types of patents. You got what are called utility patents and design patents. Utility patents basically protect like the functional features of an invention, kind of how the invention works. Design patents protect what an invention looks like. So if your device or your invention has a unique look to it, you can get a design patent that protects the look or the appearance. But usually utility patents are going to be the better way to go if they're an option, because it's going to protect the functionality of your invention, not just one specific version, but all possible versions that have that same functionality. And so usually that's what people are trying to pursue, at least as a starting point or as a priority. And that's where you do have the provisional application as an option. Design patents, if you're looking to file a design patent application, there is no provisional option. You basically just jump right into a full, what's called a non-provisional design patent application. And that is not something you want to do by yourself. They can be tricky, even though they are very simple. There are a lot of strict rules involved. And so if you're looking to do a design patent, talk to an attorney to help you with that. For utility patents, though, again, you might be able to do a provisional on your own, as we'll get into here. And there's similar types of patents in other countries. And so as I've kind of mentioned already, a provisional application, it's not examined, as someone said earlier correctly. It's just holding your place in line. It's holding that filing date, specifically for up to 12 months. And so what's expected of you within that 12-month period is that you file the full what's called non-provisional application. And if it's all done properly, when you later file that non-provisional application within that subsequent 12-month period, it gets backdated and it's given the same filing date as your provisional application. So it's as if no time is lost. And again, that's important from a prior art perspective because prior art gets cut off as of your earliest application filing date. So if I file my provisional today, anything that comes out after today is not prior art. And that still applies even if I file my non-provisional at some point within that next 12-month window. The prior art gets cut off today regardless. And so the sooner you file that provisional, the sooner you're cutting off that universe of prior art. Beyond the U.S. filings, as I mentioned, I mean, there's ways to string applications together in other countries, and that's typically done through what's called a PCT application, stands for Patent Cooperation Treaty. And much like the provisional holds your place in line in the U.S. for up to a year, a PCT application can hold your place in line internationally for up to roughly 30 to 31 months. And so I've included just a couple little timelines so you can kind of see how the order of things in which they're filed. Again, you might try to do a provisional application yourself. Anything beyond that, though, is where you want to involve an attorney to help you with those further filings, both in the U.S. and with these PCT and what's called national applications after that. And so just I have them here just for your reference, but again, your self-help should stop right here, if not sooner. For a design patent, again, there's no provisional option, and it's also you've got a shorter what's called priority period. So with utility patents, you've got that 12-month window between filing the provisional and these other applications. With design applications, you've got 6 months. So you file your U.S. design patent application, and then you have 6 months to file in any foreign countries where you might want to pursue that. Again, this is all something that you would work with an attorney on, and so they would help you kind of calendar things out and keep track of the stuff for you. So this is just here for your reference. So this slide just kind of talks about different reasons why you might want to start with a provisional. If you can't can't afford it, if you're still developing things, etc. So I'll just leave this here for your reference. But again, we'll just assume that most of you are looking to file a provisional for one or more of these reasons. So before getting into that, just really touch briefly on patentability searching. So what I mean by that is doing a search of that universe of prior art to see how unique is your invention. Is it potentially unique enough to be deserving of its own patent, or are there things out there in the prior art that come too close? And that's really a determination that's better made by a patent attorney, but you can at least do some of the searching on your own to see if what you can come up with. If you find something out there that's basically identical to what it is you've done, well, that's probably a situation where it's probably not worth pursuing, or at least you can come up with or find the closest prior art to then take that to an attorney and then get their kind of reasoned legal opinion as far as whether your invention's patentable or not. And then doing it that way could still save you some time and money. But these searches are not required. That's what's important to keep in mind. You don't have to go out there and do a patentability search if you don't want to. It's obviously can be helpful to help you make those determinations so that you can decide, okay, is this worth spending time and money pursuing, or should I just take this thing to market without going for a patent if it's not unique enough? The only requirement that you do have, though, is if you are aware of prior art, you legally have to disclose that prior art to the patent office when you file the non-provisional application. So not for the provisional, but when you later do the non-provisional, you have to provide basically a list of any prior art that you're aware of. If you fail to do that, if you're aware of prior art and you don't disclose it to the patent office, that's considered committing fraud on the patent office, and that could be used to cancel or invalidate your patent down the road. It's a common strategy that defendants will try to use if they're sued for patent infringement. They will try to invalidate your patent using one of these techniques, and so it's a very important requirement, and it's something you definitely want to keep in mind. So any prior art that you're aware of, keep a list of it and give that list to your patent attorney for when it comes time to do that full non-provisional application. So if you are going to do your own searching, the best tools to use for what we call patent literature, so in other words, looking for prior filed patents or applications or issued patents, the best tool is Google Patents, and this is the URL to it. You basically use it just like the normal Google search engine, where you would use kind of just plain English terms that would describe aspects of your invention, and then it will return as results any published applications or issued patents that use those same terms. And so if you do a good enough search using kind of precise enough terms, you could turn up very relevant prior art doing your own searching. The nice thing is that the Google Patent Database is not just US patents, but also the PCT database, Europe, Canada, Australia, most of the kind of English language databases out there, and even some non-English where there's English translations like China and Japan. So it's a pretty robust kind of one-stop shop database to use if you are going to do any kind of patent searching. Again, though, prior art is not just patents, but anything else that's out there. And so in addition to searching Google Patents, it is also good just to do kind of general internet searching as well to see what else might be out there. And again, anything that you come across that you think is potentially relevant, save it, keep a list of it, so that you can turn that over to your patent attorney as part of that non-provisional filing step. So as far as provisional applications, the nice thing is that there's no required format or specific language that you have to use. The key is that just the necessary information has to be in the document. So you don't have to worry about writing claims or using specific legal jargon or anything. It's just plain English descriptions that describe your invention, the different components, how to make and use it, etc., along with any drawings, photos, flow diagrams, etc., that you might have. Even with those, like when you get to the non-provisional step, there's very specific requirements as far as the style of drawings that you're allowed to submit. But with provisionals, it could literally be color photos, it could be napkin sketches. I mean, anything and everything can be thrown into a provisional application because it's not examined. You're basically just creating a pool of details that you'll use later when it comes time to do that non-provisional application. So the more detail you can include, the better off you're going to be down the road for that non-provisional filing. And that's the key, is that the whole point of the filing provisional is to establish that filing date, to put your flag in the ground so that your later filed non-provisional is given that earlier filing date. But you only get that earlier filing date, what we call that priority claim, if that provisional has enough detail in it. So in other words, if I'm trying to claim features A, B, and C in my non-provisional, then A, B, and C better have been disclosed in the provisional to a sufficient degree in order for me to get that priority claim. If I'm claiming A, B, and C, and I've only disclosed A and B in my provisional, A and B might get the earlier filing date, but C is not going to get the earlier filing date. So in other words, any prior art relevant to C that came out after your provisional filing date is going to count. And so you want to be as detailed as possible so that you cut off that universe of prior art and get that earlier filing date for anything and everything that you might later try to claim, as much as possible at least. And so when you're preparing that provisional, as far as what details you want to include, and again, as I mentioned, you'll be given a copy of kind of a skeleton outline document that you can use to drop these details in to kind of help you organize. Again, there's not a required format, but this document will at least kind of help you organize your thoughts and help you organize the disclosure that you're going to be putting together. But as far as the details to include, typically you start with like a brief discussion of the current state of the art. So in other words, this is how things are currently being done, or these are the types of products that are currently out there that try to solve the same problem that my invention solves, but mine does it better, basically. So you just kind of give a what's called a background history, like just again, general history of the current state of the art. And then you start to talk about from there, what are the problems with the current state of the art? I mean, obviously you come up with this invention because you're solving problems that you identified with the current state of the art. So what are those problems? What are the shortcomings of the current state of the art that your invention aims to solve? And then based on that, you then kind of transition or segue into your invention being the solution to all these problems. So there's been this existing need in the industry for a solution to this problem. My invention is that solution. And then from there, you go into the details of your invention. So if we're talking about a physical device, talk about the different components of the invention. So typically, like what's helpful to do is start with like just like a parts list, basically. Just list out every component in your invention, and then you can kind of then transition to go into more detail from there. So again, if this is my invention, we have like a cylindrical housing. We have a little spring-based clicker. We have a little clip, retaining clip, whatever you want to call it. We have a writing implement or writing tip. So I mean, you just do a parts list as a starting point. If we're talking about an algorithm or a method of making or using something, then you want to list out all the steps that are involved in that method. And then if we're talking about, again, something tangible, mechanical device or a computing system that has different modules, talk about after you've kind of listed out those parts or those components, talk about how they're arranged well relative to one another, how they work together. So again, the writing tip is positioned within the cylindrical housing. Maybe it's coaxially positioned within the housing. So you want to talk about how are these things arranged? How are they engaged with one another? How do they work together to achieve whatever functionality they're intended to achieve? Those types of details. You also want to talk about all possible materials of construction. So plastic might be the preferred embodiment, but this could also be made out of metal or wood or any other material now known or later developed. Same thing with different sizes, shapes, dimensions. This thing is cylindrical in the preferred embodiment, but maybe it could be like triangular in cross section or hexagonal in cross section. So just try to broaden things out as much as possible, so that we're not just covering your preferred embodiment, but all possible embodiments, so that we're not just protecting this, but if a competitor tries to come up with some alternative workaround, ideally your disclosure is going to cover those workarounds as well. So that's really what we're trying to do here, is not just protect your specific version, but we're trying to prevent anyone from doing anything similar as well. And so kind of related to that, again, alternate embodiments or components that could be substituted. So think about, okay, this is my invention, but how might a competitor change this to try to work around or create their own version? And then you include those descriptions of those alternate embodiments in your provisional, so as to basically say that my rights shouldn't just cover this, but this version and that version and any other version I can think of as well. Additionally, if you're thinking about other potential features that you might want to include, like in future versions, like version 2.0 or later, then make mention of those now in this provisional, so as to establish a filing date on those particular details. Even if it's like a pie in the sky feature that you might never even incorporate yourself, if you put that into your patent application, even if you never pursue a patent on that particular feature, the fact that you've put it into your application now creates prior art that's going to prevent anyone else down the road from getting a patent on that feature. So you're kind of what we jokingly say, refer to as spitting on the cookies, basically. Like by disclosing anything and everything in your document, you're preventing anyone else from trying to get patents on those features down the road. And also keeping open the option for you to get patents by virtue of putting those details into that disclosure. And then in addition to those written descriptions, any drawings or photos you have, if it's a physical device, like just photos of this from every angle, or if you have CAD drawings or hand sketches, like any and all of that, include that as drawings to just help support whatever it is you're describing, but also potentially catching things you may have forgotten to describe in the written portion. If it's shown in the drawings or the photos, that could still provide enough support to get that priority claim later. If we're talking methods, then having like flow diagrams and things like that could help illustrate what you're describing in words. The only thing that you don't want to include in a provisional is any trade secret information. So if there are aspects that you're hoping to keep confidential, you don't want to put those into a patent application, because these will eventually become public. And at that point, you would no longer have trade secret protection on any confidential information. So keep those details out of your disclosure. Just a couple more slides here. So once you have that document together, typically you want to file it online through the Patent Office portal. This is the link to do that. And then what you include as part of that submission, you have what's called the specification. That's that written description that kind of what I just listed in the previous slide. And you can use that skeleton document that you'll get as the doc file to submit. Any drawings, photos, etc. You would compile all of those as a PDF file, just like a single drawings file. And then there's also what's called a provisional cover sheet. You'll get a copy of that. You'll see it's just basically your name and address and things like that. And then most of you would be what's considered a micro entity. So there's an additional form, very straightforward form that you complete, and you submit that as well. So you take essentially these four items, you submit it through the portal. You pay the filing fee, which again, if you're a micro entity, you pay $65 to the patent office. That's the current provisional filing fee. And once you click submit, it's patent pending at that point. And then from there, you just want to make sure that you're calendaring 1 year from that date, because that's the hard deadline to then file that full non-provisional application. And because that's something you don't want to do yourself, you should really be calendaring about 9 months out from your provisional filing date to start talking to an attorney, because a lot of times attorneys will need like sometimes 4 to 6 weeks, sometimes longer, to prepare that non-provisional application. So you want to make sure to give them enough runway. Don't reach out to them when you're a month away from the 1 year deadline. They might still be able to do it, but they might charge you extra, like a rush fee to do it on such short notice. So at least 9 months out from the provisional filing date is when you should start talking to a patent attorney to help you with that next step of doing the full non-provisional. Just a couple last points to make. One is patent ownership. And the bottom line here with this slide is, if you are working with somebody, if you hire someone to help create something for you that you might ultimately later try to patent, get a written agreement in place with them. And in that agreement, as I mentioned earlier, you want to make sure that there's language that says anything they create for you, they agree to transfer their ownership interest over to you. Because the default rule is that whoever creates something is the owner of that intellectual property, unless they agree in writing otherwise. So if there's no written agreement that says you own what they've created, sometimes courts will say that they still own it and you just have a license to commercialize it, but they could also commercialize it separately without your involvement. So if you're working with others, have written agreements in place. Usually they're called assignments. And these are typically things you can find online, or an attorney can prepare one for you. Like you could just do a search for like independent contractor assignment or invention assignment, and you can probably find something that's pretty usable. But this stuff has to be in writing and signed, preferably before they actually start doing the work for you, to make sure that you're actually going to own those creations at the end of the day. And then the last thing I'll just mention is, again, as I mentioned earlier, a patent is not a grant of permission to take your product or service to market. A patent gives you the ability to stop others from doing the same thing as you. But you still, even if you're able to get a patent, you want to make sure that you have freedom to operate. So you want to make sure that you're doing that research as well, making sure that whatever your product or service entails, doing the research to make sure no one has a patent already on any aspects of that product or service. And that's something an attorney or a mentor can help you with as well. But just a good thing to do before you go to market, because if you find something that's potentially problematic, it's a lot easier to pivot and come up with a non-infringing workaround before you go to market rather than after, where now you're being hit with a lawsuit potentially. You've got to recall product, you've got to destroy product, you have to pay damages. It's just a whole can of worms that you can avoid by just doing this freedom to operate research before you actually go to market. And that goes for not just the products and services, but also the names you operate under. So even if you're kind of a commodity business, like you're selling clothing, whatever name you're operating under, you want to make sure that that name is free and clear to use and not going to infringe someone else's trademark rights. So this freedom to operate issue is an issue for any business, whether you have proprietary technology or not. So with that said, this is my contact info. I invite you to reach out to me by phone or email if you have any questions. Usually email is better, just to make sure that it's kind of stays top of mind until I'm able to get back to you and give you an answer. But I'm also happy to take phone calls about anything that was in this presentation or anything specifically you're working on. And looks like there's just one last question here. Yan May asks, is it true that Alice Mayo software applications that have succeeded show successful memory and fewer errors for educational apps? Ergo, learning 30% faster, 40%, blah, blah, blah. Yeah, I'm not quite sure what you're asking there, but with the Alice/Mayo standard, it is going back to the software patents and the subject matter eligibility. That's kind of the cases that came down that kind of narrowed the scope of what's potentially patentable in the software realm. But typically, yeah, I mean, if someone's come up with an algorithm where from a technical standpoint, they're doing something on the algorithm side that allows the computer to do something better, whether it's fewer errors or faster learning rates, things like that. If that's attributable to some new technical development, then that is something that's potentially patentable. Is Alice Mayo in the process of being refined or overturned? God, I hope so. But we've been living with it for about 11 years now. And I think at this point, I don't think the Supreme Court's going to take it back up. I think it's going to take some legislative changes in the actual statutes to provide clearer guidance or just a better rule. I definitely don't agree with the standard, but I mean it's just the rules that we have to play by currently. But yeah, we'll just have to see with time. Any other questions at this point? I know I kind of sped through those last several slides, but yeah, like I said, you'll get a copy of everything. You'll get that skeleton outline document. And again, if any of you have any questions, don't hesitate to reach out to me.